Mark mentioned, we went at a seminar in Tennessee, and we're all familiar, this committee is all familiar with the Tennessee problems. Their legislature had a real situation. They had to have a special session of legislature to address prison overcrowding. And one of their bills is that they provide that this bill here is an outgrowth of one of their bills, which provides that if you increase or enhance a penalty, then you must provide a corresponding appropriation. Now, to answer your question, Mr. Scoggins, this goes through the process and it follows the current budgetary problems of requirements that we have now. And so what we've done is we just pull this in, and if you have a bill that passes through this committee, which requires, in other words, enhances a penalty, and the note attached to it shows us the impact, then that you must, for that bill to become effective, it must have a corresponding appropriation in the appropriations bill, and then go through that process. So really what it does, it does follow the present budgetary process.
And I think what Judge Town is saying that he's actually putting the horse before the cart.
That's right.
Well, the bill is drawn, it provides that the prior law will prevail if the appropriation is not made. So if the appropriation is not made, even if you pass this bill, if the appropriation is not made, prior law will prevail.
Which means, so you don't have the, that's right, you don't get the increase.
I doubt seriously if we're going to be able to make any appropriations that are not in the appropriation.
I understand. But you see, but what we're trying to do, if it does slip through, in the case of these bills slip through on us and we enhance the penalty and not realizing what the cost is going to be.
So it will revert back to prior law, even if it passes, it will revert back to prior law if the appropriation is not made.
That's right. And it's a good bill. It's aimed at making, if you're going to increase a penalty, you've got to look at the cost of it, and that's all it does.
Professor Joseph, is that correct? What Mr. Scoggins is saying?
That's my understanding of the statute. And Mark spent a good bit
Mark,
of
do
time.
you agree with that?
Working on
that
trying
would
to
revert to the previous law. The appropriation is not made.
They're the experts on the fiscal side of it, but I mean, it's working in Tennessee.
I want to, since I'm going to be asked that question on the floor of the House, but I want that to be carefully checked, Mark, and I want it to be provided with the correct answer. And subject to that, I think I've got no problem with this bill.
Mr. Chairman, if I might point the committee members' attention to page 6, beginning in lines 5, running through the end of the page, which sets forth what happens in the event appropriations as required by this act are not provided.
Page 6, where, Mark?
Beginning on page 5, it sets forth.
Page 6, line 6.
If funding is not made as required by this chapter, then
That's
such
right.
law will be inoperative and shall be deemed to be without effect and should not be deemed to have repealed either partially or in its entirety the former law.
That's right.
Former law shall prevail. That's it. That's what we were looking for.
We've also set up,
It's clear.
we've also set up dates which will allow the
And the former law should become operative on October the 1st of the year in which a required subsequent appropriation was not made by September 1st of that year. So I think that clearly sets it up, Mr. Scott.
Yeah, I read that already.
With notice.
Take care of my concern. I'm on the appropriation.
Yes.
It
Well,
also provides for public notice.
Mr. Valentine, you wanted to make a motion? Okay, Mr. Valentine has moved that House Bill 1479 be reported favorably. Any objection to it being reported? No amendments were necessary on that bill, Barton? Or anyone? Okay.
all right, House Bill number 1482, which is a criminal procedure bill that allows a motion for the reduction of sentence under certain circumstances. This bill here, I would like to maybe change it to not change it, but to say that it's a bill that allows a district judge to modify a sentence. If you recall, last year we passed a bill which allowed the district judges to modify a misdemeanor anytime after execution of sentence. And plus, those felonies which were punishable in the parish jail. No, it's not without hard labor. That, for the first time, extended it into the felony region, the motion to modify. This would allow the district courts to consider, if it chose to do so, a motion to modify a sentence. Now, the court may reduce...
You say you want to make an amendment.
No, I just said it, I like to call it a little different than what it's in the title. It says motion to reduce, but it doesn't, that doesn't go far enough to describe the motion that we're talking about. The motion to modify.
Do you think we ought to call it that in the legislation? That's what I'm asking. To modify rather than reduce.
Well,
To modify.
Yeah, to modify, reduce, or change, we could do that. But it really, that's what it is, Mr. Chairman. It's a motion to reduce the sentence, suspend the sentence, or order that the sentence be served concurrently with any other sentence or sentence being served. If the court suspends the sentence, the court shall place the defendant on supervised probation. Now, it's got some safeguards in it, and it's a radical change in the law, and I'm going to admit that.
And what I wanted to mention, in all fairness to the committee, and the committee paid careful attention, so there'll be no questions. I introduced this by request because I think we need to air all of these laws, give them, and see if they're worth putting into our law or not. The district attorneys are in opposition to this particular, and there are several people who have personally stated some problems with this to me when they saw it. But with that admonition, I think that we need to discuss it fully and see if we think it's something. And the thing I'm interested in, Judge, is to see what good will this render. What's the ultimate good that will come from this piece of legislation?
Mr. Chairman, let me tell you the reason that I feel very strong about this bill. This will allow what we call a shock treatment type of incarceration. I can take a defendant and say give him a 6-year sentence or a 5-year sentence or whatever, and place him in the penitentiary, knowing at the time that I'm going to consider him maybe to modify his sentence and put him into an alternative program. But then it gives me the opportunity to send him to DOC, get him evaluated there, get the psychologicals on him, and get it back, and I'll have a little more of a rundown on what this guy's doing. Let him serve 180 days. Then I can come back and reconsider that sentence. This used to be the federal law, and it's done in a lot of states. In the state of Georgia, they use the motion to modify this particular provision of the law in their state to take 1,000 people out of their penitentiary system and put them into alternative programs. Now that saves a tremendous amount of money. That's 2 prisons, gentlemen. But what I'm saying is it doesn't have to be the district judge does not have to do it if he doesn't want to, and if he grants that motion, he must do it contradictory with the district attorney. Now,
It's not ex parte.
That's right.
It's with the district attorney there to present his side of opposition to that particular sentence. Mr. Scoggin, you had a statement to make before you left.
I wanted it. First, there has to be a motion to reduce, right?
Yes.
Or modify. How many motions can be made?
only one.
Just one?
And and it's done contradictorily, as he said, Mr. Scoggin. Have we changed the wording to modification or modify rather than reduction, Lord?
Not yet.
I haven't.
Members, the pertinent parts that would be changed would be on page 1, the title would be corrected to authorize the court to modify certain sentences on line 1. Line 10, reduced would be changed to modify. On line 14, reduced would be changed to modify. On page 2, line 5, reduced would be changed to modify. On line 16, page 2, reduced would be changed to modify. Line 18, reduced would be changed to modify. Line 23, reduced would be changed to modify. And on line 25, Reduce would be changed to modify.
You have some comments, Bart?
Mr. Chairman, if we change reduce to modify, would that allow an increase?
No.
No.
Line 15 would set forth what the judge could do for the imposition of sentence for one who had served 180 days in actual custody. And on page 2, line 6 would provide for the circumstances in which the defendant had been sentenced to imprisonment at hard labor exceeding 30 years and had served at least 10 years in actual custody, which would be to reduce or otherwise
Is that correct, Bart?
I think that'll do it.
Well,
See, we're
You're
getting,
just changing the name of the motion as
That's
opposed to.
all
should not be increased.
see, then.
Right, no increase
But-
would be permitted.
Okay.
That's
So what other comment did you have?
That's it.
Now, let me point out one other thing too. If we ever get into a situation where we have a critical problem in the overcrowding situation, this would be a tool that the district judges, contradictory with the district attorney, would be able to look at those prisoners in the penitentiary. Now, you say, well, you know, if we sentence them there, we're going to just keep them there. But if the state of Louisiana gets in that situation where we got a overcrowding situation where we're going to have to start releasing prisoners from the prison, and we've approached that several times, as you're all aware. If we ever get to that point, who would be in a better position to do that than the district judge and the district attorney, who is the one that put him in there? They got to, the ones going to be responsible back to the people in their communities. Whereas if you got the other hand, where the DOC is faced with a problem of turning people loose, then you got to rely on the pardon board and the parole board, and as you're aware, that didn't work too well recently. So I would
And
say
the process is long and tedious and to be perfectly honest, fraught with political interference.
yes. So I still say that even though that I have many of the judges now, you know, I might as well tell you on straight up, I think a lot of judges would be opposed to this because they have a feeling that they're going to be swarmed with a bunch of hearings.
Motions for
But that's not really true from
modification.
what I gathered, and I've checked on this law in numerous jurisdictions across the
How many
South.
states have this?
Just about every state has this law. Every southern state just about has.
Well, I had a
It's quite
personal,
common in common law.
Judge, I had a personal experience with this, and one of the people that, family that I knew, an individual, was sentenced completely different than, what was promised, so to speak. And really, the judge was not happy with the sentence that he had granted, but his hands were tied in that particular case. And he was promised to be in the intensive, what do you call it, the
Intensive supervision.
intensive incarceration program. Of course, then the DOC found out he was not eligible, but then there was nothing that the judge could do under the circumstances. But do we have anybody that wants to speak in opposition to this? Have you prepared a card?
Yes, there's a card up there for Mr. Adams.
Oh, well, come on up and identify yourself. Judge, you can stay at the witness stand. You probably be wanting to answer some further questions too.
Gentlemen, my name is Buddy Caldwell. I'm the district attorney in the 6th district. I'm president of the Louisiana District Attorneys Association. We are very much opposed to this bill. I had looked at it, not previous to this time, but I consulted Mr. Adams, and there are very important reasons for our objection to this bill. First of all, I don't know that we're in a situation right now where we need to get ourselves in a modification of sentencing position. One thing I want you to remember, when the district attorney and the judges and the defense attorneys make a plea bargain arrangement and we go into court, that arrangement is is normally made under the facts and circumstances at the time the defendants. It's normally a compromise situation where the defendant gains, the state gains, and we don't have to go through the expense of a trial. What we are doing in this bill, I can tell you one thing hadn't been said at this table right now, is you are going to subject every single plea bargain that we put in front of the court to this motion. I'm going to tell you something else. I don't know how many of you guys handle habeas corpus petitions, but the ineffective assistance of counsel is bringing the criminal justice system to a halt in this state. I personally handle the habeas corpuses. The judges are throwing every single one on us, and there is no prisoner who's been convicted of a felony in this state who doesn't know when he gets in jail that all he's got to go is to either get his jailhouse lawyer or whatever, file a petition for habeas corpus in the state, take it through the state level, then bring it back to the federal system.
But Buddy, what does that have to do with the bill at hand?
This bill at hand, under the circumstances of habeas corpus, gives rise to an ineffective assistance of counsel argument if this motion to reduce is not made in every single case.
I don't follow your logic.
The logic is if a guy is sentenced to 10 years, waits the appropriate period of time, if his motion for ineffective assistance of counsel, he can file a habeas petition, and this motion will have to be made. This bill says he only gets one motion. And if his attorney does not make a motion to reduce, you're forcing every defendant to file this motion. Every single one. Otherwise, you subjected to an ineffective assistance of
Has
counsel.
this been the experience in other states that Judge Tanner said, has many other states which had this same law in effect? Mark, do you know, does anybody know how many other states has this provision?
Our experience has been with the southern states, and most southern states have it, particularly with Georgia.
Now,
where we have-
Buddy, do you know if that has been the case in those particular states?
Representative Miller, I do not know what the situation is with anybody except normally in Mississippi. I do have some close connections over in Mississippi since I'm right across the river. And I understand that I don't believe that this is exactly the same scheme. I would have to be shown that before I can believe it. I am never impressed by what other states are doing because Louisiana is different in nearly every area, including our approach to a lot of criminal law. And I do know the everyday workings of the system. I'm a frontline man myself, and I know I handle habeas petitions, I handle plea bargains, I do the felony trial work myself personally, as well as all these other things we've got to do. And I can tell you, we need to look at this more carefully.
There would be a duty, this bill imposed upon the attorney for the defendant to apply for this modification in each case, is what you say?
I would say that it is a sleeper backdoor duty, yes. That it would create a good grounds for a good sharp attorney, and those are the ones that we got to watch out for, and it create an additional burden on the indigent defenders across the state, because in most of the poor areas, like I'm from, we got two people down there handling 6,000 cases a year, just in Madison Parish. So when they come through, they got to go up and make this motion in every one of them. So it leaves us more wide open than some of the more sophisticated jurisdictions that got money to keep somebody in court all the time, where we can't.
Mr. Boldenheim had a question in the meantime.
I just wanted to ask the judge, will the correction institution offer have any input in this matter of, that we're discussing? I mean,
Yes, they would.
Will the warden, somebody involved in the correction?
Sure, they could call in a witness they want. The DA can call in a witness and present on any evidence whatsoever. And to answer Buddy's question, I think the defendant might not want this motion filed because they only file it one time and it's not subject to review. We were very careful. This is the defendant may not invoke the appellate or supervisory jurisdiction of the appellate court to review the denial of a motion to reduce the sentence. If I had 6 months ago entered into a plea bargain with a defendant in the DA's office, I'm not going to grant that motion. And I would be very, because if I did, then I would be giving grounds probably for a writ of habeas corpus that I changed something or did something different from the thing. So I'm not going to grant that motion.
And you know it's contradictory to you, wouldn't you, when you read that?
That is another tremendous concern.
Okay, it is concerned because you're gonna have to provide the staff to go to these particular hearings.
That's right, in every case. In every case, that means now the judge has got to take up more court time for a contradictory hearing. And let me say there's another built-in sleeper in this problem. What do you do when there's all the families in court? You sentence somebody, the judge can sentence the guy to 10 years, 18 years, and in the back of his mind, he knows, well, wait a minute, he's going to come back by, you know, we can reduce this later. It is unconstitutional to increase a sentence. I think your modification language in here is leaving you wide open too. Because anything that you do in here is subject to increase it. For example, if you add any additional probation, unless it's a modification under 895 or one of these other statutes, you're leaving yourself wide open for another constitutional attack. But the cost on this, we can't get into court enough now. We just rejected another bill and opposed another bill to enforce contradictory hearings and bail reductions and increases. We can't afford to get the people back into court. And every one of these cases are going to move. And you take the pressure off the trial judge. When the family of the victim is not there, then 4 months later they come back, all of a sudden here's a motion to reduce the sentence, and you lose the ability of the public to track these cases. The pressure's off on a particular case. So 6 months back, they run in one afternoon in court and get the sentence reduced. And you got to force the victim to track it, and they come holler at the DA and the other people in the criminal justice system. There are too many problems with this bill that are legitimate problems. And I have not had the opportunity to examine the experience of the other states. In the cases that I've been told that other states are doing this, every time I looked into them, that wasn't the case. Their system was not the same, and we were talking about apples and oranges instead of what we really needed to be looking at. The cost factor of saving costs by virtue of this bill, I would like to see a fiscal number. I can't conceive of how this is going to do anything but tremendously increase our cost in going into court and forcing us into these contradictory hearings and putting about $2 a page on every other transcript that we got to have for every habeas corpus petition that this is going to cause us to have. So, and then the fact that every plea bargain we make from here on out is going to be subject to a motion to decrease, no matter how well conceived. Now we're going to have to go in and balkanize them for the very cautious judges to see if they, when they waive their right to appeal, then this is going to bring up another question as to whether or not the appellate consideration, whether they're going to waive a motion to reduce the sentence. This is going to be
the impact statement says, the conclusion of the impact statement. I don't have the fiscal statement. No quantitative impact can be specified for this proposal because its impact is directly tied to the application of it by the trial courts. It may serve to relieve some pressure on the appellate courts by permitting the trial court fresh opportunity to amend sentence when issues are raised. Instead of you having to go to the appellate court, you might be able to handle it right there at home, is what they're saying. But while we're doing this, Bruce, why don't you come up to the table? In fact, I've wanted to do it since the meeting started. It's a pleasure for me to introduce the new Secretary of Public Safety and Corrections, old friend and colleague, Bruce Lynn. Thank you. We're going to let you talk some more, buddy.
Let me have time to rejuvenate myself.
You sounded rejuvenated enough to me.
Mr. Chairman, members of the committee, it's a pleasure to be here. This was one of the bills that I handled last year in the task force for prison overcrowding. Now, I can't speak from the legal ramifications and all of it. We have our experts here, and Buddy certainly is an expert on his side of the table. But the just common sense factor that if you can reduce a sentence after it's been imposed, or modify the sentence after it's been imposed by a judge, then that would give us the right to reduce prison crowding, overcrowding, as we are faced with it every day now. Now, just because you have a motion there to reduce the sentence, it can be denied. Now, I know the judges would assume a lot of responsibility here, and they are willing to do this. It doesn't mean that you have to go through with it. It can be denied. So I think that only where it's granted does it give you a problem. And I think that we are moving into the era where judges are going to have to assume the responsibility of making this judgment, because we just can't build enough prisons, and especially if a person, and I'm not a bleeding heart nor a do-gooder, as we have so accused a lot of people of being, as when I sat on your committee. But the common sense thing is that if a person has been put in prison for several years, has been sentenced for several years, and then by all behavior patterns and whatnot, his sentence can be reduced, it makes sense. And I just would appreciate if y'all would look at this bill serious, because it will mean a lot to prison overcrowding. My good friend Buddy and I worked together on some bills last year. I think he got mixed up on this one again last year. He might have opposed it. But that doesn't mean he's a bad fella. He means well. But we have to...
I can't imagine that he'd have lenient judges up there in that part of the country either.
No, not from where he's from.
Not what I hear. I think they try to execute them for minor crimes, from what I hear.
All of that. But anyway, this is a serious bill, and I hope you give it serious consideration so we can move forward with this. Thank you.
Judge Tanner.
First, I want to say, I feel sorry for Buddy. He works real hard. But every time he works hard, I have to work hard. I mean, I have to be up there on that bench, and when he comes to court, I come to court. I'm not going to work myself if I'm not going to grant 100 of these motions at a time. I'm going to, and many of them, we're going to find that the DA is going to send an assistant over there and say, Judge, we oppose this. But he's not going to get up and really oppose it. And if he wants to have the victim, he can bring the victim, the mom and the daddy, and all the people he wants to bring there if he wants to really oppose it. Now, you tell me if it's not going to be many district judges in this state going to sit up and have an open, big fight with his district attorney over somebody on a motion to modify a sentence. It's just not going to happen. And I think that this part of it, when you start talking about the money that they're going to have to spend, is not going to be something they're going to have to face at any time. This is going to be able to be used in those instances and where you can do some good and you can change the sentence. But you're not turning these people loose, remember. You turn them into alternative programs. And it gives them that shot in the penitentiary. They're not going to take it too lightly when you turn them loose into an alternative program.
Let me ask Buddy a question about that. I'm trying to learn from this too. When you get notice of a pardon or parole board hearing, do you usually attend? Have you attended in the past?
We normally do not attend unless it's one that is a very serious case that we feel there's some problem that we may get blitzed on.
That's the point I'm trying to make about this particular procedure. Wouldn't it be a lot easier to be appearing in your home district court rather than having to travel to a distant prison to oppose a pardon or parole or whatever, or having to prepare the documents for the appellate court and travel to New Orleans to the Supreme Court? That's what I'm thinking about. And look, I am not soft on crime. I want it